The British American Banknote Company was formed in 1866 and was a spectacular success because it held contracts with the Canadian government for the printing of banknotes. Burland was the president of the company and held a majority of its shares. Some of the company's substantial profits had been retained as a reserve fund rather than being distributed to the shareholders as dividends. Those shareholders sought an order compelling the company to distribute the profits. The court refused, saying they were not aware of any principle which compels a joint stock company, while a going concern, to divide the whole of its profits amongst its shareholders. Whether the whole or any part should be divided, or what portion should be divided and what portion retained, are entirely questions of internal management, which the shareholders must decide for themselves. If the shareholders could not obtain a distribution of dividends through a board resolution, they could not have a distribution at all. A second claim against Burland was that he had held an interest in another printing company which was wound up. Burland purchased a lot of the equipment from the liquidator of that other company, quite cheaply. He then sold that printing equipment to the British American Banknote Company, of which, remember, he was the president, at a handsome profit. The shareholders claimed that he was a trustee of this profit and should pay it back to the company. The court said this would have been true if Burland had made the purchase as a director. However, as an individual, he was entitled to purchase the equipment and sell his property for whatever price he wanted. The court said there is no evidence whatever of any mandate to Burland to purchase on behalf of the company, or that he was in any sense a trustee for the company of the purchased property. It may be that he had an intention in his own mind to resell it to the company, but it was an intention which he was at liberty to carry out or abandon at his own will. From this case we learn that there is no rule requiring a company to distribute profits as dividends, and that a court will not interfere in the lawful internal management of a company, and there is nothing to prevent a director, in their individual capacity, from dealing with the company at a profit.